Okay, we have started. Wonderful. Hello, everybody. Great to see you for this last session of the 2021 MCLE Spectacular. Here is hoping that in 2022, we'll all be live and in person, at least for part of this program. So we're just going to give a couple of minutes to let everybody come in before we get started. I hope you have all been enjoying yourselves. A reminder, if you missed any of the sessions and want to see them, they will all be available on this same platform through January 21st. So you can go in and watch anything that you'd like. As long as you watch the entire video, you will also get MCLE credit for it. You'll be getting an email later this afternoon with a little more information about that. So, and we, as always, love to hear from you, get feedback. So in each session, there's a files tab that has the event materials and also the evaluation form. So please, if you can, fill out the evaluation form and send it in. It really helps us with our preparation for all of our programs. Okay. All right. Well, I think we are going to get started with our introduction. So let me spotlight you. All right, Erica, take it away.
Hello, everyone. I am Erica McKenna, your incoming 2022 CCCBA president. Feel free, on behalf of the Contra Costa County Bar Association, I would like to welcome you to this final session of the 27th annual MCLE Spectacular. We hope you have enjoyed all of our fantastic programs. We are grateful for this opportunity to learn with you over the last 3 days and are so happy you have been able to join us. Today, we will hear from the Honorable Elizabeth Laporte, JAMS mediator, arbitrator, referee, special master, and neutral evaluator, who will be speaking on lessons learned from the bench and beyond. Before we get started, I would like to introduce Heather Muirhead of JAMS, who is sponsoring this program today.
Thank you, Erica. I very much appreciate that. Let's see. So thank you to the Contra Costa County Bar Association for hosting this wonderful annual MCLE Spectacular. Happy 27th birthday. JAMS is happy to be the benefactor sponsor for this event and appreciates our partnership with the entire Bar Association to support ongoing legal education for everyone. I especially want to recognize Teresa Hurley, Ann Wolf, and Carol Lucido, and the rest of the CCCBA team for being wonderful hosts and partners and for hosting such an impressive event. JAMS Walnut Creek office doors are open, as are our San Francisco office doors to in-person and hybrid hearings. Our panelists are available to resolve discrete issues or entire cases, and our skilled case management team would be happy to provide a list of panelists best suited to handle your dispute based on their experience, background, and approach to ADR. We at JAMS always welcome any insights you would like to provide that will help us better serve you as a legal community. Thank you so much, and we look forward to our continued partnership with the Bar Association and with the East Bay community. Now, let me take a couple of minutes to introduce Judge Laporte, who is, as Erica mentioned, today's keynote speaker. I am happy to say that she is a full-time mediator, arbitrator, and special master at JAMS. She earned her BA from Princeton, an MA from Oxford, and her law degree from Yale Law School. Judge Laporte began her legal career as a clerk to the Honorable Marilyn Hall Patel at the Northern District of California. She was a partner at Turner and Broby and chief of special litigation at the San Francisco Attorney's Office, just to mention a few of the highlights. Judge Laporte served as a U.S. magistrate judge for the Northern District of California for more than 2 decades, including 2 years as chief magistrate judge. As magistrate judge, she presided over numerous civil cases with a robust docket that included patent, trademark, copyright, business, class actions, employment insurance, environmental, antitrust, and civil rights litigation. She also successfully presided over settlement conferences and chaired the development of the court's e-discovery guidelines. While on the bench, Judge Laporte launched the Women's Attorneys Advocacy Project with the support of the court and a group of outstanding women attorneys who volunteered their time, putting on programs focused on overcoming obstacles to and maximizing opportunities for women attorneys' success. When she's not helping litigants resolve their cases and being all around professionally inspiring, she enjoys going to spend time with family and spending time in nature. And just as a quick note, Judge Laporte is going to reference various studies and sources as part of her discussion about elimination of bias in the legal profession and litigation trends. If you would like those resources, please contact us or Judge Laporte's office directly, and we will provide them to you. Judge Laporte, take it away.
Thank you very much. I appreciate the kind introduction and being asked to speak here. It's humbling, to put it mildly, to be in the wake of Attorney General Bonta and Dean Chemerinsky, who not only was giving you some education, but is a frequent educator of judges, federal judges for sure. So I've seen him do that many times. I, again, appreciate the opportunity. I wanted to start by speaking about some of the challenges and opportunities that women face in and out of the courtroom. Personally, as a female litigator and then a judge for over 2 decades and now at JAMS, I'm very proud of the advances that women have made in the profession, but I also recognize there's still room for more progress. But when I look back, when I was growing up, I only knew one woman attorney, even though my father and grandfather were attorneys. But all the attorneys we knew were men, except for one who was trust and estate, so no litigators. When I went to law school at Yale, and I graduated in 1982, the number of women professors ranged from 1 to 2 to 0 at some of the time. So that was quite something. As you heard in the introduction, I had the great honor of clerking for Judge Marilyn Hall Patel, who at that time was in her 3rd year on the bench as the first woman on the Northern District of California Federal Court. And she remained the only woman for a while, for several years at least, before she was joined by wonderful Judge Fern Smith. And then quite a bit later, she became the first female chief judge of the court. Happy to report that things are very different now. And while I was there and currently, it's a very diverse group of judges with much more gender balance and diversity of background. So I would say I understand that the first woman joined JAMS about the same year, or as the same year I graduated in 1982, which was a few years after it was founded. And a century before that, Clara Foltz became the first woman to join the bar in California. But she was relatively lonely. You've probably heard about the term the glass ceiling, which was coined in the late 70s. In the 80s, the Wall Street Journal had a report about it, and in which it discussed authors identifying the hard to see or imperceptible impediments that hindered the progress of female managers from advancing due to corporate traditions and prejudices, they said. Other terms have come along to encapsulate some of the other barriers or issues faced. One is sticky floors, where women are held down to lower level jobs and don't get a chance to seek management positions, and glass cliffs. So even if you get to the glass ceiling, the glass cliffs where women in leadership can be precariously positioned to fail. So these are still to some extent reflected in our courts. In 2018, just about 12% of federal judgeships were held by women. And Also in that year, there were only 700, although there were 754 judges who'd served on courts of appeals, only 91 of those judges were women. State courts in general, the research shows that there are about 30% of judges and 80% of judges are white. Now, I do think we're doing better in the Bay Area and our courts, including at all levels, including the California Supreme Court. The US Supreme Court, as I think probably you all know, there have only been 6 women total to serve. And the gap did not improve. In fact, it went the other way during the previous administration, where the last president appointed more than 90% white nominees and more than 80% male. So there is room for improvement there. I've had the pleasure to get to know and do programs with Professor Joan Williams at Hastings, who's done a lot of pioneering work on women in various professions, but including the law. Of course, she's a law professor herself. And she and her daughter have written a very good book, What Works for Women at Work, that summarizes a lot of the recent social science research in a way that's easy to grasp and is I think, well said, and particularly relevant, I think, here is one of the themes she calls it, prove it again, where women have to prove themselves over and over, don't retain credit for things that they've done before. And the tightrope, which I think is something I think I've experienced, and perhaps many of you have, that it's a very narrow path for women professionals to be perceived as both competent and likable or warm or friendly. When they're perceived as likable, they're often perceived, we are often perceived as not competent. But when we're perceived as competent, we're also often perceived as being unlikable or worse. And of course, we've been hearing in recent years about unconscious or implicit bias. Just thinking about it myself, I realized that it's embedded in many customs and practices, but in our language. One that occurred to me, perhaps because I'm only about 5'2", is that the word stature is often used. It has 2 primary meanings. One is literal height. How tall are you? And the other is prestige or reputation due to ability or achievement. And I think that may be no coincidence. Now, it's not all gloomy. There's been a great deal of progress, and there are also steps that women can take to help themselves and each other, and supportive men, as so many are in the Bay Area, can help with that as well. There's avoiding the cultural pressures not to speak up, and then if a woman at a meeting says something that's useful and positive, but it isn't picked up on, this is one of the patterns that has been found by social scientists, and Joan Williams discusses in her book. But that's ignored, and then a man says the same thing and is congratulated for such a good idea. Other people can chime in and say, yeah, yes, you're right. And I'm glad you see the value of the opinion that was expressed earlier by so-and-so. That's one example. Others are, mentoring and sponsoring, helping. There are many things, and I'll talk about some of the efforts we made at the Women Attorneys Advocacy Project, which I launched in 2015 at the Northern District of California Court with the help of an outstanding group of women attorneys. from different aspects of the profession. What we were at a court conference where we heard from Professor Williams and Professor Deborah Brody at Stanford about some of the barriers. And that was right before the lunch break. Coincidentally, we're on lunch now. At least some of you are eating perhaps. And I thought, here I am with a bunch of really talented attorneys. Maybe there's something we can do about this, as they had discussed the barriers. And so I grabbed about 5 women and we sat down at lunch, and then we started having regular meetings and brainstorming. And that led to putting on a series of programs at the court with terrific support from the court, as well as programs at Stanford and at Hastings that came at the issues from various perspectives. We had panels of successful women attorneys who talked about how they'd overcome obstacles, how they'd seized opportunities, what they've done, what their advice was. We had panels of judges that included judges from our court, as well as the Chief Justice of the California Supreme Court at one point, and others. We had a terrific, talented trainer who does training in speech and voice presentation, because sometimes due to our upbringing, women have a bit more of a tendency than men to sometimes express their opinions very tentatively, or not take up space and show presence. So that was another approach. And I've heard people have come up to me and said, those programs really made a difference to them, which was extremely gratifying to me. We then also put on a program at another organization that I've been pleased to be on the board of for many years, and maybe some of you are part of that, the Association of Business Trial Lawyers in the Northern District of California, I should say in Northern California. It's not just the district, much broader. And we had distinguished attorneys and Justice on the Court of Appeal, Terry, who told us about times that she'd been mistaken in her own courtroom, but not wearing the robe, for being clerical and not, that's Justice Terry Jackson, I should say, for being just the clerk and not the judge. And similar tales, very accomplished women attorney who was waiting for the deposition to begin, in which she asked, "Why aren't we getting started?" The opposing counsel said, "Because we're waiting for the attorney on the other side." And it just assumed that she was not doing the deposition. So anecdotes like that tell you there's room for improvement. There's recently been, I just got published an excellent article by my former colleague and friend on the Ninth Circuit, Judge Margaret McEwen, together with an attorney at the law firm, Roberta Liebenberg, that talked about the impact of the pandemic and positive changes to the offices regarding, they call their article, hazards of female lawyers being, quote, office moms. They noted that, of course, in the pandemic, many people have been staying home. And so they haven't been as much office moms, quote unquote, but they've been often having to juggle childcare with children out of school and home office work. And in some cases, that burden has fallen more heavily on the women, which has been, from what I read, had an unfortunate impact on women's participation in the professional workforce. But as things open up, what this article is pointing out is that somewhat unseen and underappreciated is that the tendency has been for women attorneys more than men to be the ones who perform the role they call the office mom. But the one who, or another word they use is the glue, the camaraderie, the morale, the team building, the things that aren't necessarily glamorous, but do make a big difference in overall productivity, well-being, welfare, health, wellness, and productivity. And they pointed, there was an article in the Journal of Applied Psychology in 2005 showing a double standard essentially for how what work was expected and what credit was given in this field, that where a man stayed later and helped at the office, he was rated 14% more favorably than a woman for the same behavior. But when a woman declined to stay and help, she was rated 12% lower than the man who did the same. In one study, undesirable, unglamorous tasks were given in a mixed gender environment, so both men and women, and the women volunteered twice as often as the men, but only when it was clear that no one else was going to step forward. The second experiment, they gave an undesirable task to an all-male group and found that men volunteered at the same rate as women. So there's a social process going on here that perception and reality have some ways to go. What the authors recommend is recognizing and rewarding this kind of glue work, helping a colleague with a presentation, leading a mentoring program for more junior associates, coordinating a summer program, planning social gatherings, bringing in the cake for a birthday, taking notes at a group case conference or the like, to give credit for that, and to use metrics for it, and also spread the load of this more equally. So using objective metrics can help overcome the tendencies that implicit biases bake in. So they recommend too that individual female lawyers learn to say yes to things that are appropriate, including things that are going to be perceived as career advancing, and say no when it's something that really they don't have the time or ability to do, and it would be perfectly fair for someone else to do it. Keep your own tabs and metrics on them and be able to bring them up. Volunteer for the more high visibility opportunities as well. And of course, seek out allies and mentors and sponsors, and be one when you can be. There are certainly many other things that institutions can do, supporting flexible schedules, recognizing childcare and time off without penalizing progress. We talked about mentorship. They're all important to retaining women. And it's important that men also both are offered these opportunities, but take them so that it's less viewed as a stigma for women. Oh, she's distracted by childcare, but he's here to work. And I think we are making progress in that, where men take paternity leave and take advantage of use the flexibility, do some of those things, and it becomes more equal. And of course, mediators and arbitrators and judges all need to be sensitive to participant schedules, allow for breaks and accommodations when when that's appropriate and needed, such as during telephone and video conferencing. I think it's important to understand that, particularly at the days of the remote working, which aren't completely over and we're unsure where it's going, where people have double or triple duty with childcare, pets, what have you, to be accommodating. And we've also probably, I certainly have, and maybe you have had the plus side of that, where it's very humanizing and can be heartwarming to see someone's pet or child on the screen. You understand and can empathize more with other people, not just see them as adversaries. So I think we've had that. I had a particularly lovely instance of that in one of my mediations, where it involved a design patent for holding some food, which was kind of in a circular, semicircular sort of bowl type of shape, with much more details than that, of course, that were being fought over. But at the end of it, and we resolved it, one of the lawyers had his young daughter modeled this like a crown on her head, which was very lovely and a very nice ending to that day and evening. So another takeaway, I think we know from the research that diverse teams reach better outcomes. They can bring more different perspectives and collaborate together. So that's important. And of course, law firms and government as well can't afford the loss of talent of having women have attrition, where you lose the talent of women lawyers and the investment in the training and the positive results that a diverse team can bring. And of course, a lot of these problems are definitely exacerbated for women of color. So that's important to understand as well. So I want to switch to a slightly different topic, but one that is related, which is the importance of civility and professional courtesy in our profession. Important to all of us, but it's also especially important to this topic of overcoming barriers to women and people of color. So there was an excellent article by Justice Edmond and Justice Jesner in the ABTL, Association of Business Trial Lawyers, Los Angeles summer issue 2019, that said basically, we're right to be focusing on civility in the profession, and we should also recognize that this incivility can target women at times more than anyone else, in ways such as being talked over, sexist jokes and comments, comments that trivialize gender discrimination, being addressed unprofessionally or critiqued on your personal appearance or attire. Certainly, I think it's not uncommon that women get called by their first name, but the men by their last name, or things of that nature. And as I mentioned before, with even judges being mistaken for non-lawyers, for being clerical or people who should get the coffee or the like. As I'm sure you've experienced yourself, those who behave with civility are experience more satisfaction, and conversely, unprofessional behavior, if you're the target of it, is definitely reduces your satisfaction. I'm pleased to see that the Contra Costa Bar Association here and the Superior Court have adopted excellent civility guidelines and requirements including recognizing that vigorous advocacy is not inconsistent, in fact, is consistent with courtesy, and trying to not be influenced by ill feelings that the clients may have, and to maintain a professional demeanor, not denigrate opposing counsel, parties, witnesses, the court, of course, and obviously not engage in any kind of discrimination based on age, gender, sexual orientation, physical appearance, mental impairment, religion, race, while practicing law. And we had a similar set of guidelines in my former court, the Northern District of California. And these are very important, I think. And, you know, at times I had to remind parties of them. As a judge, I think in general, you see more civil behavior in the courtroom than what goes on outside the courtroom unsupervised. But there are times when I've seen opposing counsel cut off, speak over, interrupt, denigrate, shake their heads, etc., at the other side. And I would intervene and counsel against that. And there have been briefs which similarly used very personal language, ad hominem or ad femininem, that is just inappropriate. It is also not effective, I can tell you, as a judge and now an arbitrator, mediator. It's at best just noise and distraction, but at worst, it really gives me a bad feeling about the person who's using, or the people who are using that rhetoric. And it's not as effective as just using the facts to illustrate a point. Like if you think something is not correct and not as represented, instead of saying that person is a total liar and can never tell the truth, et cetera, just put in, actually, this is the full quote from the case or the email or whatever. That's more effective. But again, civility has a special, is important for everyone, and it can be especially important for attorneys who are women or people of color, being treated on average less civilly than others. And it's something we can all help with. For example, if that's going on between opposing counsel and let's say an attorney is denigrating a female attorney and not listening to her and talking over her, or saying, you know, well, who's really calling the shots? It can't be you. It may need a senior partner to step in and say, yes, it is her, and I have full trust in her, and you should deal with her, etc. So we need to help each other. I'm going to change gears more completely and talk about the rise in, well, some IP issues and others that I deal with, both formerly on the court and now at JAMS, mediating and arbitrating, and sometimes special master. I wrote an article on the rise of trade secret litigation in California, which has been on the rise. As of 2019, the second largest verdict in the state that year was $845 million, which was awarded to a semiconductor chip processing software company against a company founded by two former employees that it had or a subsidiary had in Santa Clara, who were accused of working in secret using stolen trade secrets to get a head start in development and siphon off a major customer. And these cases have a number of advantages for the plaintiffs and require sophisticated defenses, because the plaintiffs can often be craft and persuade through a narrative of theft that often either a former employee, as in that case, had secretly stolen trade secrets for their own benefit, or start a rival venture, or in the case where two different companies collaborate for a period looking to do some kind of joint venture or project. So one reveals trade secret information to the other, and although there's a non-disclosure agreement, of course, the question is then if it doesn't happen and there's a falling out, one may claim that the other then used that secret information to get a head start or get an unfair advantage or get free ride on their own work. And in addition, these trade secret cases have an ability perhaps to overcome a situation in California, which is not in every state, where we have very protective law for the right to leave one company and go to another and not be hamstrung by some contract that purports to stop competition. So it voids almost all non-compete agreements and doesn't recognize inevitable disclosure. So you can't assume that there's going to be disclosure, but if you can prove trade secret violation, then there is the possibility of recovery. And the trade secrets, unlike patents and so on, they don't expire as long as you've protected them and kept them, taken reasonable efforts to keep them secret. So there's been more focus on trade secret litigation in recent years. Patent cases, of course, continue to be present very big challenges. Things are still evolving and still complicated by the law that the Supreme Court issued starting with the Alice case about patentable subject matter and is it eligible or not, as well as all the complications of parallel proceedings with the PTO, the Patent and Trademark Office, and the PTAB, and many parties pursuing actions in both forums. And I used to be asked, and courts all over the country are trying to figure out when to stay in action, when to not stay it while there's something going on that could impact it at the federal agency, the PTAB or the PTO. And then there's the ongoing venue issues. Still, although the Federal Circuit and the courts have made it more difficult to to just pick any venue, which tended often to be in Texas. There's still many venue fights, and the Federal Circuit seems to be intervening increasingly. We'll see where that goes. I've also had some special master experience since leaving the court and joining JAMS, where I've been appointed, for example, to look at the adequacy rule, make recommendations as a special master on the adequacy of infringement contentions. And in another example, in a creative settlement where the parties settled most of the case, but they wanted a ruling on one particular claim, whether it was infringed or not, and they'd agreed on the outcome that would flow from the finding of infringement or non-infringement. But they wanted that done in an expeditious way, but in a way that I think brought them clarity. So that was a creative use mediation. All discovery now, to a large extent, is e-discovery. Years ago, I was called by a reporter at one time after I'd made a ruling about missing computer data and so forth. And they said, oh, you're now an expert in e-discovery. And I said, what's that? But of course, now we've all heard it at length, at great length, maybe too much length, but there's both, kind of the arms race of more and more data that can be stored cheaply and kept for a long time. But on the other hand, how do you access it and search it? But also more efficient ways to do that, not just the more old-fashioned but still useful search terms, but also the use of machine learning and artificial intelligence, which poses new challenges. Both can be very efficient, but also can be a black box, which is daunting. And the need for quality control. Standards, not perfection, but the need to make sure that it's reasonable. But there have been studies, you may know this, that have shown that we tend to have thought of all human research and review and reading eyes on documents, et cetera, as being perfect, but in fact, it's not. To err is human. And so the electronic ways of searching can achieve just as good results, if not better. But it's a trust and verify situation, typically. So last, I'm going to turn to the benefits of ADR, particularly in this area, in the era that we're in of uncertainty in terms of how much in person can we do, when the courts are going to be open or closed, are the courts who have the responsibility and the constitutional right of speedy trial for criminals, accused, that is, but in criminal proceedings. Can they clear their backlog of civil cases that's resulted? So it's become, if anything, even more important to make appropriate use of mediation and arbitration alternative methods. Of course, when I was on the bench, I did thousands of settlement conferences, but one thing I didn't see was mediations or settlement conferences of disputes that hadn't been filed in court, because of course, by definition, I was trying to settle cases that had been filed in the court. Now I've had the valuable and interesting experience of having a fair number of mediations before dispute is actually filed. And in many cases, the parties have stipulated to toll the statute of limitations or other deadlines to allow that. And it can provide both obvious advantages and savings of time and money, but also saving the parties from going public with a dispute where it might have bad consequences for both. For example, in an employment case, it could be not only embarrassing potentially for the company, at least the allegations, but it might hamper the former employee, if it is a former employee, or even a current employee, from being viewed favorably by another future prospective employer. Not that that's necessarily fair, but could well be a reality that employers reluctant to hire someone who's sued their former employer. So that's just one example. There've been many other types of cases. So that's an interesting and to me with somewhat different dynamics and opportunities, but certainly continues to be useful to have mediations in cases that have been filed and at various stages. And I was very pleased and at first surprised, but not for long, at how when suddenly last March had to transition to, well, it's more than a year and a half ago, so to virtual mediations and arbitration at just how well those functioned. I think we'd all assumed that the way we'd usually done it in person was definitely better than any alternative. But what I've actually found is the advantages of virtual mediations can and often do at least equal and or if not outweigh the disadvantages that certainly saves time and money for the parties, particularly parties who are far away. So I've done mediations, arbitrations with far-flung parties. Some might be in the San Francisco Bay Area, while others are in China or Korea or Taiwan or Europe, etc. And the savings in travel time and expense, hotels, etc., is big. And decision makers who might not be able to come in person can more easily participate. Including CEOs and insurance representatives, etc. And then, of course, those who have medical issues which would prevent them from traveling, or child care responsibilities at night, that helps with the traveling. So there can be a lot of benefits, as well as, for example, in arbitration, remote witnesses. Sometimes they can be presented through a videotape deposition, but also possible to have participation through live video. So there's been advantages, and I think going forward, we're going to see, yes, resumption of in-person proceedings, but I don't foresee complete replacement of virtual proceedings, either in whole or in hybrid part, due to all those advantages. And I think if properly set up too, with the viewing the participants, you can get quite up close and personal and really see them on the screen in a way that sometimes you can't in the courtroom or a large conference room. So to summarize a little bit, as we know, justice delayed can be justice denied. So mediation can help avoid that. So can arbitration when the courts are clogged, and the parties can agree to, or of course, in the first instance, craft an arbitration agreement that works for the parties, but they can also subsequently stipulate to modify it in a way that suits them, whether it's more discovery or less discovery, for example, more expedited, less expedited, reasoned ruling, or just a bare bones result. All sorts of, how much depositions, no depositions, there's many options. And similarly, use of a special master or referee can be tailored to what's needed, particularly when the courts just don't have the bandwidth. So those are all some thoughts and hopefully somewhat useful lessons that I've learned along the way, both as a litigator, a judge, and now arbitrator, mediator, etc. at JAMS, that I wanted to share with you, and I hope you have found useful. And if there are questions, I could answer some, perhaps, or at least try.
Wonderful. Thank you so much, Judge Laporte. So yes, if you have any questions, please put them in the chat, either in the Zoom chat or the one on Pathable. And I did want to make a note that we have added additional materials. Some of the things that Judge Laporte had mentioned in her presentation, we now have added to the other materials that were provided. So this is your opportunity. I have to say that many of the things you mentioned, Judge Laporte, have actually come up in my discussions with different members, literally over the last couple of days. Civility in the courtroom, and people even mentioning, people being uncivil with female judges.
Yeah, that does happen. And even female mediators and arbitrators.
Yeah.
I remember one particular oral argument in which I said, politely and firmly several times that I'm just not convinced by that argument. Maybe I'm wrong. You can take it to the Ninth Circuit. And the attorney just got apoplectic and red-faced and basically said, Your Honor, you can't, and then stop saying, Your Honor, you can't think that. That's just not right. Are you listening? It's basically.
Oh, brother. Oh my
And I
goodness.
have had people tell me how to do my job.
Oh.
But mostly not at all.
Well, that's
Mostly
good.
it's been a real pleasure. Otherwise, I wouldn't still be doing this.
Yeah. Okay, I've got a couple of questions for you. Are there studies that collate case outcomes by gender or race of advocate or jurist?
Good question. I don't know the answer. I do know what I referenced, the general research that diverse teams in all kinds of fields come up, make better decisions now, but I don't know. I haven't read the details of those studies. So that's an interesting question. I probably need to pose it to a jury consultant.
Oh yeah. Oh, that's a good idea.
I mean, I certainly, you do, I think that sometimes it appears to be strategic decisions as to what gender or ethnicity, et cetera, to appeal, to put forward on some particular issue, like having a woman defense attorney in a sexual harassment case, for example, is not uncommon. But I don't know the answer. It's a good question.
All right. Yeah. Okay. How about, have you seen more arbitration agreements that specify remote or virtual appearances?
No, but not the agreements themselves, because usually they're older. But if you mean the original agreement, the contract, whatever it was, but yes, in terms of agreeing how they want this arbitration conducted. And then I know the JAMS rules, and I think the rules that I'm familiar with different organizations do allow the presiding arbitrator or panel to make a decision about it based on health circumstances, et cetera, whatever it may be.
Okay, great. Thank you. Any other questions from folks? Please put them in the chat. The other thing that you mentioned that has come up in many discussions I've actually had with Erica McKenna, who is our incoming president and runs a law firm and has 2 young children, is about the humanizing effect of remote appearances, and that you do get to see family and you see pets and you see the painting behind somebody and a little bit of their house. And yeah,
I think that's right. And I think that's a positive for our profession.
Yeah. Have you noticed, do you see it making much of a difference in people's, say civility or anything like that?
Well, I think it's subtle, but I think it does. And of course, I also think it's important for somebody in my position as the arbitrator or mediator to both try to model that behavior and regulate it. So, to watch when tempers get short, to reposition things, to make sure that, there's equal opportunity, dialogue, et cetera. And if necessary, separate people. I mean, one thing remote does allow, sometimes, unfortunately, as we probably all have experienced at one time or another, generally it's not the attorneys, but the clients just can't stand to be anywhere near each other physically. And even if you keep them in the same, in separate physical conference rooms, they would be horrified to meet in the hallway or the restroom or the lunch table. So that they don't have to worry about when they're all dialing in remotely.
That very, very true. That definitely helps in that way.
Oh.
Okay, there we go. A few people have said thank you very much for your presentation. You know, your impressive experience is just, it's fantastic to hear from you in such a variety of issues as well. And we're really pleased that you were able to take the time and speak to our members and to close out our spectacular this year. So
Well,
thank
it's an
you.
honor, and I appreciate that very kind feedback. Thank you.
All
And
right.
good luck to everybody.
Thank you. And thank you, everybody, for attending the MCLE Spectacular. And like I said, we hope to see you in person next year. Have a wonderful Thanksgiving holiday, everyone.
Bye-bye.
Bye-bye.